All right, passing it off to you, Nancy.
So I would like to ask the folks on the call for their indulgence. This is the first time I've done this with Hively. So you get my audition tape, and there may be a few bumps in the road. I have reviewed the materials. I'm familiar with the subject matter, but I may need some help along the way. So let's talk about, next slide, please. The basic, what we're going to do. Here are our topics. We're going to go through some of the basic documents of an estate plan, and then we'll take a deeper dive into trusts, estate taxes, and how you can plan around them, what probate is, choices or decisions that you can make, what a homestead is, and what to do with adult children. Moving right along. So who needs an estate plan? Not just because I do this for a living, but everybody. If you're over 18, you need an estate plan. How complex it will be depends on your circumstances and what you want to do. But estate planning is not just for the wealthy, and it's not just for after you're gone. So for sure, it deals what happens at death, but it's also to manage your affairs during your lifetime if you're unable to do it yourself. We have, Jenna, you follow it? Next, I'm up to the 5th slide of 3 basic documents. So every adult who's competent, and which is to say anyone who's not under guardianship or conservatorship, needs at least these 3 documents. You need a will, which says what happens to your stuff when you're gone, and it does other things. You need a power of attorney, which has nothing to do with lawyers. It means authorizing someone to make financial decisions for you. There are 2 types. There's immediately effective, which can be dangerous because if I sign a power of attorney authorizing my brother to act for me, he can do whatever I can do. So I really have to trust that he's going to do the right thing, he's not going to liquidate my brokerage account and go off on vacation that he's always wanted to. He has to do what's in my best interest. That's the first type of fiduciary. We're going to talk about different types of fiduciary over this presentation. So you can have an immediately effective one, or you can have a springing one. So a springing one comes into effect when you are unable to act for yourself. And I don't like springing ones. I understand people's hesitations, but my hesitation about it is I want my agent to be able to hit the ground running without having to go to a doctor and get a note saying that, yes, I can't do it, and then taking it over to the bank and trying to explain to the bank that the note is good and the power of attorney is good, and I'm not there for whatever good reason. I want something that's immediately effective. So we can, if we have time, we can talk about how to hold powers of attorney in abeyance. We also like to have them durable, because that means when I sign a durable power of attorney, if I become incapacitated, my agent still has the authority to act. When I'm gone, my agent has no more authority. Now, a healthcare proxy is like a power of attorney, but it's different in that it is only for making medical decisions, not financial ones. And it's only when I am unable to make or communicate them myself. So it comes into being when I'm unable to make or communicate them, and then it lapses when I regain capacity to make them. Now they're moving along to the next slide. There are optional provisions, which some people like to put in the healthcare proxy and some people like to put in separate documents. One is a living will, which says, I don't want extraordinary measures. If it's inevitable, let me go. And then some people put organ donation on your driver's license. You can also have it in a healthcare proxy. I don't like to do that. But I like to have it in a separate document as a directive as to remain. It's not even a living will. So the next slide tells us about trusts. Now, remember we said that a will goes into effect when you die? A trust is immediately effective from the time you sign it and you put money into it. And there you can have a single revocable trust for estate planning. You can have 2 revocable trusts, or you could have what's called an IRA, an irrevocable life insurance trust. Now, basically, the difference between revocable and irrevocable is how much it can change. How much can you change it? So if you have one trust that two people are involved with, it does not become irrevocable until the second person dies. If you have two revocable trusts, and this spins all off estate tax and state law. The two revocable trusts may provide a way to shelter some of your assets from tax. I practice only in Massachusetts, only for things that somehow touch or concern Massachusetts. So people who live here, people who own property here, even if they live in New Jersey, if they own Massachusetts real estate, that's my gig. And in Massachusetts, the state taxes estates of decedents when the decedents die. This is your probate estate. This is your taxable estate. It's bigger. It includes more. If that's over $2 million, they tax you on the amount over $2 million. So if it's over the estate tax threshold and you want to reduce that, there are a few ways that you can reduce your estate tax, the dollars in your estate. And one is you can spend it. So I currently have, let's make it up, $5 million, but I'm fairly young and I will probably spend it down before I die. I've already reached my peak earning years and I'm coasting on the downside. So you can spend it, you can give it away, and you can give it away either through charity, or you can give it to people, or you can put it into an irrevocable trust, like an ILIT, a life insurance trust, which means that you no longer own it. And because you no longer own it, it's no longer in your estate. Let's see, we covered that well enough. Let's go on to the next slide, which talks about estate taxes. So remember I said in Massachusetts, they tax you if it's over $2 million. This is each person, each taxpayer. The federal estate tax is $13.99 million, because somehow we just couldn't find another $10,000 to make it a nice, square, even $14 million. So for a married couple, it's $27.98 million. However, for people dying after this year, the law goes back to the $5 million threshold from before 2017's law. It is indexed for inflation, so it'll probably be about 7 to 7.5 million, but that's almost half. And the estate tax goes up to 40% of the excess over the threshold. So if you die with let's do it easy. If you die with $23.99 million, you will be taxed on $10 million over 13.99 million. But if you die with $27 billion and you leave it all to your surviving spouse, that's not taxed at all. There is an unlimited marital deduction. So you may wonder, why doesn't everybody just leave everything to the surviving spouse and not bother with more complex estate planning? And the answer is because we don't know which spouse is going to die first. If you tell me who will be the surviving spouse for sure, I can do a really easy estate plan, but nobody can tell me for sure. So, okay, so we've already covered the marital deduction. Moving on to the next slide about estate tax planning with two revocable trusts. We've touched on this briefly. So if you consider that every human being is a separate taxpayer, and everybody has a separate exemption amount, having two revocable trusts will allow you to double your state estate tax level. So you can save estate taxes and ensure that more money goes to your beneficiaries. But the problem is, if you're a married couple, you have to separate your assets between the two trusts to maximize how you're going to get up to the estate tax threshold. And then after the first spouse's death, you have to keep that one's trust in place and keep track of what the surviving spouse takes out. For some people, the tax savings are much more valuable. They don't mind the administrative hassle. For other people, the administrative hassle wipes out any tax savings. And honestly, if you're right at the level of whatever your state's tax threshold is, you may want to think carefully about tying yourself up in knots just to get the benefits of this. Some people hate paying taxes and they will do just about any level of contortion to avoid it. So if you have a life insurance policy, you can put your life insurance policy into an island, which moves it out of your estate tax, out of your taxable estate. So once you set it, there are a few limitations. One is you have to own the policy now. It's not something that your employer owns and you're the beneficiary, or you're the insured and it's your death that will trigger the payout. You have to own the policy. And so then you give it up and you put it into this trust, and you have to live for 3 years after you set up the trust in order for the insurance policy to be out of your estate. The trust is functional, it's operational. Whether the value of the policy will be in your estate depends on you living 3 years beyond setting up the trust. You have to have a separate tax identification number for the trust, and you have to have separate bank account for the trust. So then you can deposit the money, you can make a gift of the money required to keep the premium on the life insurance policy. You can make a gift of that to the island, and then that will fund the life insurance policy going forward. You also have to tell all the beneficiaries every year that they have a withdrawal right. These are called crummy letters, not because they are deficient in some way. It's the name of the case. Mr. Crummy, C-R-U-M-M-E-Y, had the what nobody really wants to have, which is a groundbreaking estate tax case. So now let's talk about probate. Probate is the process under state law that deals with the succession of assets after someone dies. It's only probate assets. So let's talk about what probate assets exclude. Anything with a beneficiary designation, like a life insurance policy, like an IRA, a 401k, a 403b. Those are not anything that passes under the will because there's a beneficiary. It's nothing you own jointly with another person. And it's nothing so bank accounts don't have beneficiary designations like a retirement account. So a bank account has what's called a POD or a TOD or a transfer on death, and it goes directly to the person you have named. So your probate assets are the items you own individually. It can be real estate if you're the only owner of the real estate, or if you owned it with someone who has since died and you're the only surviving owner, that real estate passes under your will. If you don't have a will, every state has laws that says what happens to property, and it may not be what you want. So even if your distributive scheme of where your property goes ends up being the same, I want to leave it to my husband, and if he's not around, I want to leave it to my children. You may want to have a will so that you get to say how that works a little more cleanly and to exclude certain creditors. So in Massachusetts, the probate estate has to stay open for a year from the date of death. But you can make distributions from the estate long before that. The timing is also, how long does it take to get a probate up and running? The fastest I think you can do it is 10 days after the death in Massachusetts. I am currently working on probates. We haven't even filed them. We haven't gotten anybody appointed for people who died last summer, because you have to get all the paperwork together and get the heirs. Heirs are people who take if you don't have a will, and beneficiaries, they're the people who take under the will. We have to get them all to sign off on various levels of the paperwork. So probate part 2, people talk about, oh, I want to avoid probate. Probate is bad. I want to avoid it. Avoiding probate is a good goal. It is not an absolute requirement, because sometimes you want to have it there just to sweep up assets that you didn't plan. The best way to avoid probate is to have either joint owners, a beneficiary, or to put the asset into a trust or another entity. If you want to put your real estate in Massachusetts into a trust, you need a deed to the trust signed by all the owners, preferably, although there are exceptions. You need a trustee certificate saying this trust, you don't want to record the whole trust because it's got sensitive and confidential information, but you want to have an abstract of what the important provisions are. And you probably, if it's your primary residence, you want to have a declaration of homestead. So let's see what we have. Ants, how are we doing so far? Okay. Bruce asks, do all trusts need an EIN? Yes and or yes but. So I have a trust. It's revocable. It is not irrevocable yet. And it flies under my social security number. It has assets in it. It has assets pointed to it because I've named my trust as the beneficiary of certain assets. Its EIN is my SSN. When the trust becomes irrevocable, either because I make it irrevocable or because I die, it needs to get its own EIN. Now, can a trust be a beneficiary? Yes, yes, it can. Okay, other questions? Jen, did I miss anything in the chat? Okay, galloping on. Ancillary probate. So Massachusetts has exclusive authority over Massachusetts real estate. If you live in New York and you own real estate in Massachusetts and everything else you own is in New York, that's great. You can go probate your will in New York. Nobody objects to that. But if you want to deal with the Massachusetts real estate, you need to come and play in Massachusetts. And if it's not already in a trust, it's a probate asset, you need to open an ancillary probate. Ancillary means sort of like auxiliary off to the side. Because you've already got a personal representative appointed in New York who's already been authorized to do whatever. The will has been proved and allowed. It's a will, it's witnessed, it's got the requisite requirement. It's got the stuff you need to have in a will. But that's a New York probate. You need to take that New York authority and run it through Massachusetts. So keep in mind that this is your probate estate, but there's more that's in your taxable estate. The decisions that you get to make. This is where we're getting into fiduciaries. Now, you may recall that I said the person you name in your power of attorney is a fiduciary who's held to a very high standard, must act in your interests, not in the fiduciary's own interests. So who's the person who holds that role in a will? In Massachusetts, since 2000, we call it a personal representative. Before that, we had two levels. We had executor for a will and an administrator if there was no will. Now it's just all personal representative. So the role of the personal representative is to gather the assets, figure out the creditor's claims, pay them off, and distribute the remainder as you have directed. So you may not need to have a probate. In Massachusetts, if there are no assets that pass under the will, you still have to file the will with a death certificate in the probate court, but you don't have to open an estate. You don't have to give notice to the creditors. If they want to come and do something about it, they can. It's there waiting for them. Now, in your will, you can name guardians for your minor children. Once you turn 18, regardless of your level of competence, you are fully qualified to do whatever you want unless you have a guardian or a conservator. So you don't need to name your let's say we have an intact family like Ozzie and Harriet. Ozzie in his will does not need to name Harriet as the guardian of their children, their minor children, because guardians come in two flavors. There are natural guardians, which are parents, and in Massachusetts, that includes adopting parents. And then there are court-appointed guardians, and those are the ones that you can nominate in your will. If you can't name a guardian, you can't require somebody to be the guardian. You can nominate, and then the probate court will appoint one. The probate court will look to see who is the nominated guardian and whether that is in the child's best interest at the time of the appointment. So you can see you choose somebody when the child is 2, and then that person sadly is convicted and is currently incarcerated in a federal prison and maybe shouldn't be a guardian for an 8-year-old. So the court will look at it at the time and make sure that things still line up. I have seen people say, I want to name my brother and sister-in-law, and my question is, okay, so if your sister-in-law dies, do you still want your brother to do it alone? And vice versa. If he dies, should she do it? What if they divorce? Do you still want both of them? This is something you should work through with your estate planning attorney. Okay, going on to slide 13. So for your healthcare proxy, the fiduciary is your healthcare agent. This person has springing authority. That means only when you can't make or communicate the decisions on your own. And it's not just if you're at the edge of death's door. Imagine you're going in for a procedure where you have to be anesthetized. And they get there and they see that a choice needs to be made. They can bring you out from the anesthesia, wait for you to recover, get your decision, and then put you back under. Or they can ask your healthcare agent. Most people would rather not have repeated instances of anesthesia. We talked about how you could have this person be your HIPAA agent. The HIPAA agent gets access to your medical records, but not to make decisions. I have separate documents for that. Even if it's the same people you're naming, you want them to have exactly the authority document that they need without slopping over into other things. You can include living will instructions like no extraordinary measures. Massachusetts has laws making healthcare proxies legally enforceable, and there are consequences to healthcare providers who do not honor valid healthcare proxies, but living wills are not binding. So why do we do them? We don't have to. I do them for clients because if they want to give their loved ones greater comfort in making difficult decisions. So we talked about the power of attorney, whether it can be durable, whether it can be specific or general. I like durable. I like immediate. I understand there are other reasons to do other things, and I'll do what my clients understand that they want to do. The next slide is even more decisions you get to make. So the fiduciary of your trust is the trustee. Think of a trust this way. There's the person who puts the money into the trust. That's called the grantor or the donor or the settlor. There are fine nuances of how these things differ, these terms differ, but for these purposes, that's the one who funds the trust. And the person who sets it up is the grantor, the donor, or the settlor. Then there's the trustee, who can also be the grantor. The trustee is the one who's responsible for making the decisions according to the terms of the trust, on behalf of the beneficiaries who are entitled to the assets of the trust. Beneficiaries come in two flavors, primary and contingent. So primary could be, if we're talking about taxable estate planning, where you want to shelter the assets from estate tax, you leave property to your spouse, and when your spouse is gone, then it goes to the children. So the spouse is the primary beneficiary, and the children are the contingent beneficiaries. A trust that has no assets in it is not a very functional trust. It has to be funded. You have to put something in it. So when my clients come in to sign their estate plans, and I'm not joking about this, we take a dollar bill to the schedule of assets. The trust is now funded, and then they can always put more assets into the trust. How you put an asset in the trust depends on what the asset is. So to put a bank account into the trust, you change the name of the bank account. To put tangible personal property, you have a collection of musical instruments. They don't have certificates of title. They're just musical instruments. What you do is a memorandum of tangible personal property, conveying them to the trust. You can also point assets to the trust where they go there after you're gone. That's a beneficiary designation of a bank account or a brokerage account, a 401k, a retirement account. And you want to include in your estate plan the remote catastrophe. What happens if my husband and my children don't survive me? Where should my property go? Now, I can always back it up with what the state statute says, but that could be very difficult because what if it's my cousin's granddaughter and who knows where she lives? Because I have outlived most of my relatives. So we like to include either other contingent beneficiaries, and then best of all, a way of determining who the ultimate beneficiaries will be if nobody else is around. And the next slide is about other documents. So in Massachusetts, we have declarations of homesteading in two flavors. There's a statutory homestead, which everybody gets. If you own a property and you occupy it as your primary residence, you have $125,000 protection, up to $125,000 in equity. So let's talk about what equity is. And this is where we get to, I'm glad I'm on Zoom. So you buy your property and it is worth this much, and you get a mortgage for 80%. The space between my hands is your equity. Now, over time, you pay down your mortgage and then you refinance, and pay down your mortgage, and then you refinance again, tapping the equity, right? But the value of the property increases over time. So the space between my hands is equity. In Massachusetts, just by owning your primary residence, you have up to $125,000 in equity protected against the claims of creditors. This has nothing to do with getting out from paying your mortgage. But if you record a declaration of homestead, you get up to $1 million in equity protected. And you can only get, I own my house in a trust. I have what's called the trustee homestead declaration, which protects up to $1 million in equity in my property. Let's see what else. Okay, documents for college age and adult children. Well, if your children have assets of their own, they need significant estate plans. But at a minimum, when children go off to college, they should sign 2, probably 3. Healthcare proxy, HIPAA authorization, and a power of attorney. I had a very nice little practice niche. It wasn't particularly lucrative, but it was really enjoyable. Student athletes who, when they turn 18 and they go off to college, their parents can no longer make medical decisions for them, can't make financial decisions for them, can't have access to their medical records unless they have executed healthcare proxies, powers of attorney, and HIPAA authorizations. Okay, questions so far? Are we barging ahead to, oh, look, sorry. I do have some questions that came over the transom before we started. So let me start with those. What is the difference between a will and a trust? So a will hits the ground running after you're gone and all the appropriate paperwork has been filed with the probate court. The probate court has approved the paperwork and appointed the fiduciary to handle your estate. This can take months. The trust, by contrast, is immediately effective. The trustees are immediately empowered until they are removed or the trust terminates. Let's see. If you have a will, does that automatically mean that it has to go through probate and take longer to settle the estate? And I'm going to give you a lawyer answer. I don't mean to annoy you. Yes, but also no. If you have a will, it must be filed with the probate court with your death certificate, but you don't need to use the will to distribute assets if they're not probate assets. There's also one small exception in Massachusetts. If you have a bank account that is under $10,000, the bank may, in its discretion, close the account and turn the money over to certain types of claimants. May. And these days, most people don't know their bankers. They're at some huge multinational bank. The branch people don't know them. So this doesn't work so well. Should we create a revocable trust? Yes, you should. Now, I need a little more information to tell you what a revocable trust will do for you, why it will be beneficial. What I tell people before I know them very well is that a revocable trust provides smooth management of assets. And if you're thinking about people who own real estate is a really valuable asset. It's probably the most valuable thing that most people own. And it has tricky, nuanced rules about how to manage it. So having title to your real estate in your trust makes it easier to manage. Okay, got another one. The wisdom of transferring management of stocks, bonds, etc., to the professional company that will be the. Whoa. Well, you're talking about a professional trustee. I'm going to punt on that. Let me go through the other questions and we'll come back to professional trustees if time permits. So is a living trust set up in one state good for all other states? One picky word issue. Massachusetts doesn't talk about living trusts. So let's assume this is what you mean is a trust that you set up during your lifetime. So if you set up a trust, it is probably good for all other states in the United States under the full faith and credit clause of the US Constitution. However, it may not have the particular language that one state requires. So in Massachusetts, we have a body of laws that say these are the statutes about what trusts are and what trustees can do. But we also have statutes that say you can opt into this provision if you have this particular language. So if you did your trust in Wyoming and it doesn't have the particular language that you need for Massachusetts, you may have a difficult time there. So what I tell my clients is you should look at your estate plan every year and you should think about updating it every 5 or 10 years and upon the occurrence of major changes. And I offer certain clients a half an hour a year listening session where they can come in, they can talk about anything they want, and they can tell me what's going on in their lives. And then I can tell them whether they should update their estate plan. How much should we be budgeting for legal expenses when setting up your estate plans? Is there a range? Yes. I can tell you what I charge for simple to complex. I can tell you my hourly fee. I would say for an individual to do a simple estate plan, no trust, no tax planning, you should probably budget between $2,000 and $3,000. If you have one person who has real estate and maybe a little more money, that would be sort of 3 to 5. If they're a married couple, I would say sort of 4 to 7, depending. Now, if you have what you might think of as funky assets, let's see, pure things that I've encountered in my practice that I've thought, oh, I really don't want to get into planning for that. Purebred animals, partial interest in a racehorse, assets overseas, some of the more obscure employee compensation schemes involving phantom stock and deferred compensation. Art, I have done estate planning for artwork. It makes me nervous, but I've done it. What else have I done this? Oh, musical instruments, firearms, boats, and not just your normal boat, but a scary boat for me. Okay. Does making your annuity and accounts the beneficiary of a trust place them in the trust? No, they don't get there until the issue triggering the beneficiary payout occurs. So let's say I have a taxable brokerage account at Fidelity, which I don't, but let's say I do. And the beneficiary of the taxable brokerage account is my trust. When I die, the asset goes to my trust. As long as I'm alive, it's mine. Now, I could set this entire brokerage account, I could put it into my trust. So it's not as a beneficiary, it's already into the trust. Pour over is usually a term used for a will that pours over to an estate planning trust. So you could have a will that says, I leave my tangible personal property to my husband, and if he's not around, it goes to my children, and if they're not around, it goes to my trust. That's a pour over clause in a will. Okay.
Nancy, there was a question in the chat. Would you approach creating wills and trusts differently if you know that some of the details will change?
No, because I have a lot of clients who struggle with, well, I don't know how to, and I say, think of something, don't think of something that's going to be good forever. Think of something that's going to be good for the next 2 years. Now, children grow up and people evolve and people get married, people get divorced, people die, other people are born or adopted, relationships evolve. Your estate plan does not cost $150 because it's designed to cover all of these likely changes the way you think you want them to go. If you change your goals, if you change your concerns, if the law changes, then you want to update your will. But we can plan for limited information. We plan under uncertainty. There's a lot of uncertainty now because the tax laws are set to expire. And they're going to go back to what they were in 2017, unless Congress acts. I don't know whether Congress will act or what it will do. So we plan under uncertainty. Other questions? Okay, moving along with the ones I already got over the transom. What are your thoughts about family trusts under $4 million rather than outright bequests? So I've been doing this for over 30 years. And in my opinion, most people are not good at managing large amounts of money. So I like to think of trusts as a nice thick barrier between the money and the beneficiary. This is not saying that beneficiaries are foolish, that they're going to buy a Lamborghini, that they're going to snort their inheritances up their noses. No, it's that leave professional work to the professionals. And if you need, the beneficiary always is entitled to information about the trust, but the trusts I draft say that the trustees have full authority to distribute the entire amount to a beneficiary. It's up to the trustees to decide. Some of my colleagues have what we call ratchets, that when the children turn 30, they get so much, and then 35, and then 40. I don't like that because if it's an automatic out from the trust, the creditors of the beneficiary can demand a distribution, and I think that's unwise. Imagine you set up a business and you personally guaranteed all the loans to the business, and then the pandemic hit, and then you got an inheritance. Do you want the inheritance sucked out to pay off the creditors? Because there's a better way to do that through bankruptcy. So I like having a nice thick barrier between the money and the beneficiary, which is permeable that the beneficiary's needs, the provisions of the trust, and the trustee's fiduciary obligations. Does that answer the question? Okay, pros and cons of a revocable and an irrevocable trust. Some people are really scared about irrevocability, about doing things that they can't undo. So some people are skittish about irrevocable trusts. A benefit of an irrevocable trust is it moves it out of your taxable estate, and it can ensure the legacy. So I have a client who's a widow in her 80s, and she set up an irrevocable trust, and she put 100,000 or so into it, and all she can get is the interest on that money. Now, I don't do Medicaid planning, but I do know about this trust that 5 years after she set it up, it is no longer available for mass health, for Medicaid reimbursement. So that's Tony's right on schedule. A Medicaid trust is not something I do, but I understand why I don't do it. If you do not have assets, the state will pay for some level of medical care. So imagine that I have $5 million, and on my way to the nursing home, I asked the cab driver to stop off at the bank, and I withdraw my $5 million in cash, and I give it to my daughter. And I show up at the nursing home and I say, I have no money. Now, a lot of us think that's unfair. And there are statutes that explain how you can do this. And the answer is 5-year look back. If I had done that, not in the cab ride to the nursing home, but 5 years before, those assets are no longer available. They're no longer countable assets. The other kinds of countable assets, well, non-countable assets, are an allowance for what's called the community spouse. So if one spouse is in the nursing home and one spouse is living in the house, there are assets that you can keep on your own. Otherwise, your money should be used to pay for your care. Oh, good. Andy asked, and it reminds me to come back to the question about professional trustees. So a really good reason to name a law firm as either executor or personal representative or trustee is they go on over time. At some point, the lawyers in the firm either resign, retire, or die, or all three, and you don't have that continuity of service. I have a succession plan for my practice, but at some point, everybody's going to be gone. So if you have a law firm or a professional trustee, like fiduciary trust, or I think there are some other financial institutions that serve as trustees. They go on forever. The problem is they charge trustee fees, which are more expensive than what I'm a professional trustee, but I'm an individual. I'm not a corporate trustee. Corporate trustees, if you have complex assets, if you have difficult beneficiaries, if you have beneficiaries who are overseas, you may want a corporate professional trustee. If your family members are generally okay with paperwork and numbers and know the limits of their knowledge and know when to hire a financial advisor, an insurance agent, a lawyer, a real estate broker, then those people could be, your relatives could be good trustees. Okay, that's right. There was one more here. Okay, so the other questions that I got before today's Zoom are very much into the weeds about naming a charity for the benefit as the beneficiary of an IRA. Basically, there are tax benefits to that. This is beyond the scope of what we can talk about. And then somebody asked about ABLE accounts. ABLE accounts are a special type of bank account for disabled adults. I think if you start with a neutral source of information like Wikipedia and put in ABLE accounts, you'll get a good summary, and then you can use it to go look elsewhere and read up further. Having no children to whom to leave our assets, what would you suggest? Who would you like to make a gift to? Do you have a charity or an organization, college, or university, any school you have a close relationship with? Is there a cause that matters to you? You don't have to have children in order to leave money to them. It could be your neighbors or your friends. All right, how are we doing on time?
We're doing well. I do want to give space for folks who are in the call today. If you have any other questions for Nancy, we can keep it casual.
I'm ready. Come off mute and ask me questions.
You did a great
So,
job.
I have one question.
Yeah.
So, yeah, we probably did our irrevocable trust after our first child was born. Now it's 23 years later. We haven't touched it yet, but we need to update it, add the other child, and do all the things you're talking about today. But are we at least ahead of the game to be able to walk in with that and say, because we have to go to a different lawyer, this lawyer that we were working with no longer does this work, but she's going to recommend somebody else.
You are totally ahead of the curve in three major ways. You've thought it through. You have an estate plan in place, and you have an attorney who can refer you to somebody who handles this kind of work. Not starting from scratch. Now, if you did something 23 years ago, I bet it contemplated that you might have more children. But boy, has the law changed since then. And I bet your goals, your concerns, your assets have also changed. And the child who was 2 years old 23 years ago has developed in a way that you have a much better sense of what would be a good legacy to leave that child under what circumstances. Does that answer your question?
Yes, yeah, and that's helpful. I mean, we used to have a bit of a jump start when we go in.
Absolutely. And
We still have we have way more questions than we would have had 20 years ago, but but
that's right. We got rid of most of the answers, so there are fewer for you to worry about.
okay,
And part of my practice is second look. So people in your situation had an estate plan drafted a while ago, and they don't know whether they need to update it. And so I look at what they've got, and I do an abstract, and I summarize what the provisions are, and I say, is this still what you want? And then we can get into the technical aspects of, do you want this level of limitation in order to get this benefit?
And so you're talking about transferring assets to a trust. Is that a taxable event?
No, you're putting it into your own revocable trust. Your revocable trust flies under the radar in terms of tax provisions. It's you as far as it is. Now, you could sell assets to the trust, and that might have tax benefits and tax consequences. So if I bought my house for $300,000, let's say my basis in it is $300,000. If I were to turn around and sell it for $1 million, there's $700,000 of gain there. Now, a portion of it is excluded if I occupied it as my primary residence, but if I put it into my trust, it has my basis because it's a gift. If I sell it to my trust for $1 million, then my trust would have the basis of $1 million. And if it sold the property for 1.2 million, it then has only $200,000 of capital gains. Did that answer your question, or did that go off down a tangent?
It was slightly bit of a tangent, but it was helpful.
Okay, so for most transfers for no consideration to a trust in Massachusetts, not all, but most, there are no tax consequences in the instance. I don't know about other states. I don't practice anywhere else. Massachusetts has enough to keep me busy. Oh, can you take assets out of the, oh, yes, yes. Thank you, Tony. The kinds of trusts that I draft, the revocable ones, you can put assets in, you can take assets out. You can change who the trustees are, you can change who the beneficiaries are. You can change when the beneficiaries get how much. You can swap assets. You could take this $100,000 asset out and put this $100,000 asset in. They are infinitely flexible. We like them for that.
Nancy, I'd like to get back to the question I asked about turning over management of stocks and bonds and things like that to a professional company, because I have a company in mind and they have asked me if I go with them as the trustee to do that. And the reason seems to be, aside from the fact that they'd make money on it, that way it would be easier to marshal all the assets when I pass without having to try to figure out what there is. I don't know. What do you think about that?
I need to ask a few questions. So do you currently have a trust?
No.
Are you thinking that you would put all your assets into a trust that you would set up?
No, I think probably the assets would be pour over, that it would go to the trust as the beneficiary of, the various accounts that I have.
So you have a bunch of accounts that don't have beneficiary designations.
They don't, since my wife died, right, there's no beneficiary designations. And I either have to make beneficiary designations or make the trust the beneficiary.
That would be through a beneficiary designation. So you've got a brokerage account and you could complete a beneficiary designation saying that when you're gone, the beneficiary is your trust.
Correct.
So this professional company wants to be the trustee, wants you to, they want to have your assets under management.
They would, right, they would like to manage the brokerage account rather than the brokerage account that I have now.
Do you get a benefit from their current management of the brokerage account?
I have no idea.
Are they offering you something a service that would help? Are you currently making your own investment decisions?
No, I have a broker who does all that.
So at a very basic level, I'm not understanding why bother. And they're saying it'll be easier to marshal your assets when you're gone. Well, but if all your assets are pointed to your trust anyway, how much marshaling, is there marshaling? Well, yeah, the assets aren't in the trust, they have to know where the assets are.
Okay, I'll go back and look over my conversations and all. I mean, I'm comfortable with this company. They have a good reputation and I think they'll do a good job managing the trust. They just kind of threw me when they asked about managing the assets. And it may, I don't know that it's necessary for me. I'm not necessarily enthusiastic about it.
So is it, when they're gonna be managing the assets, what are they going to be doing? Are they going to be investing?
Yes,
Do they have investment expertise?
yes.
Well, then I think you'd be getting a benefit right there. Better than you better than me throwing darts at the wall deciding what to invest in. They have the expertise, but you already have a broker.
Okay, I get it. So it's a question of, what I'm spending now with the broker versus what I would spend with them to manage the assets.
Yeah, I think that the broker probably, how is the broker currently compensated? Is it a commission on each trade? Is it a percentage of assets under management? Is it an annual fee independent of the value of the portfolio?
Right, yeah. Well, in my case, it's a fee for certain accounts. Of the accounts that I have with her, she gets a percentage on some, but not all of the accounts. And then they make money on certain trades, but there's not a management fee over the total corpus. And this is something we negotiated over a period of time, including the rate of compensation, which, I basically told her what I was willing to pay, that kind of thing. So, and I guess I could do the same thing with the trust company, but I'm trying to keep it simple.
So do you have an attorney who helped you with your wife's estate?
No, I did all that on my own. It was pretty simple, because everything was payable on death except for one account that she never got around to doing that, and I didn't know about it. And so that had to go through probate.
Yeah, that's very difficult. Now, are you working with an attorney to update your estate plan?
Yes, I am. I'm hoping to finalize that in the next few weeks.
That is a good source of information. Go ask your attorney.
Okay,
Oh, no, you're in Virginia, right?
correct.
Yeah, so you want, a local attorney with local expertise who knows you and knows your situation. Okay, Maria asks, you die without a will and trust and have no heirs. Everybody has heirs, everybody. Well, I shouldn't say that. The Massachusetts intestacy statutes go out, I think, beyond fourth cousins. I have the form over there. It's pinned to the file cabinet. It is very rare that somebody has no heirs. The question is, can we find the heirs? So, if you die without a spouse and without children, think of an umbrella. That's what the intestate statutes in Massachusetts are. You go up. Did you have parents? No. Did you have aunts and uncles? No. Did you have cousins? The children of your aunts and uncles? No. Did they have children? No. So then you go up another generation. Your grandparents. Did your grandparents survive? No. Did any of their brothers and sisters? No. How about any of your grandparents' nieces and nephews? Your parents' cousins. And we just keep doing this. Massachusetts says to how far out to go. But that is why you want to have a will, because you want the property to go where you want, because the intestacy statutes are not going to leave it to your favorite charity, unless your favorite charity is the Commonwealth of Massachusetts. Also, you get to choose who's going to be in charge. Who's going to be the personal representative? How the personal representative has authority to deal with your creditors. Okay, so that was the last question. You have in the slides, you have my email. If you want to email me, I will try and answer. As I said, I practice only in Massachusetts, so I don't provide legal advice for anyone outside of Massachusetts. or for matters concerning the laws other than Massachusetts. I'm a one-state lawyer. But I can, I can put you in touch with people in states where I have colleagues.